Coffin, as a basis, told in his notice of intent, says that Captain Gardner lied about telling Mr. Coffin a general statement. In other words, Mr. Coffin says particularly, I asked you if there was anything in your background which would embarrass the county. It's a general statement. And you said no. Director Sweat will come in here, as will Captain Gardner, and say he never asked that question. He asked him if he knew about the actual Drew case. That's a particular distinction. When you're firing somebody after 27 years, you want to make sure that's right. He knew that was untruthful, and in the final notice of dismissal, they abandoned that. They know it's not true. So they abandoned that. They still hang their hats on, and I'm not sure I understand why, on this other, you didn't tell us you were having a relationship, that must be misleading. But the initial is abandoned. Well, why that's important is because under the policies, Captain Gardner had an opportunity to respond. And he did so in writing. And that response in writing challenged Mr. Coffin on those two issues. First of all, it's a violation of the Policeman's Bill of Rights, which will be undisputed. You're supposed to provide witness statements before the interview. Never happened. Had Captain Doffenmeyer been here, we can use it through a report. We can show that. It's a clear violation. And Mr. Coffin knew that. He'd been the subject of at least 4 internal affairs investigations himself. So he knew that. That was a violation. But he didn't include that and didn't do that. And there's a notice of intent, and I think it was provided to you all, the response. I don't know if you had an opportunity to review it. The county, it was presented to you. As a result of that, Mr. Coffin, by advice from the county, reported his conduct to the state attorney's office and is subject to investigation in the state attorney's office for that. Also, at advice of county, he reopened the investigation for the purpose, as you'll say, to protect Mr. Gardner's due process. That's the representation. We're going to protect your due process related to those 2 claims of false statements. The evidence will show when that happened, Captain Doffenmeyer was cut out of the process. The independent internal affairs investigator, the only one that works in the Department of Public Protection, was cut out. She was replaced by County Attorney Larry Smith. Larry Smith and Mrs. Jones. They're now doing interviews under the auspice that we're investigators. And they go back, not to protect Captain Gardner's rights, but to do a whole back, and they go fishing. And they go back through everything to go fishing, to see, maybe we can come up with something. And you'll see by the way the questions are asked. They go, say, maybe we can turn this into some type of supervisory thing. And you'll see at the end they were unsuccessful with that. But they attempted to do that. Part of that fishing expedition is they demanded his personal cell phone records. Now you'll see under the policies do not allow the county to demand personal cell phone records. They have a county-issued cell phone, and of course you'll see in Captain Doffenmeyer's report, that was presented to them. There's no policy against using your personal cell phone. Yet they wanted his personal cell phone records, and when you become an employee of the County of Volusia or any other county, you don't lose your constitutional rights. They don't have a right to go digging through your things. If you go home for lunch, they don't come search your house. And we'll argue that whether that was a lawful order at a different time. But that was pointed out to them when the request was made. And Captain Gardner did go down and produce records for them. And the records reflect that the county doesn't pay for his cell phone at all in any way. And it showed the time and the amount of time for that month that he used his cell phone. Doesn't have detail, and he didn't provide the detail of who he was calling or what that substance of those calls. I don't even know if you can get that or not. But he didn't provide that to them. But he did produce records to show that it was his personal cell phone. And they had his county-issued cell phone. They're just out fishing. And that's one of the bases they have to terminate. In this process, though, there was discovered multiple Policeman's Bill of Rights violations. And that was given to the county in the way of a written letter. It was both told to them and in writing. And that will be one of the documents we provided to you today. And it's important not so that you all can make a determination as to whether or not he violated Policeman's Bill of Rights, but the process. It shows that this was not an oversight. But this Policeman's Bill of Rights violation letter gave the violation and very specific factual basis for each one. And it requested, as the statute provides, what's called a compliance review committee hearing within 10 days. That's a requirement of the Policeman's Bill of Rights, and he requested that. And you will hear the evidence today, they flat denied it. And to further deny him, they dismissed him immediately when he asked for that. They dismissed him to prevent that from happening. Of course, we have we made that request, and of course, that's pending before the circuit court. But it's important for you to understand that if Mr. Rickenwald was here, when he came in, he didn't do a new investigation at all. What he did is he inherited a process that began before he ever got there. Attorneys were involved. This thing was cast in stone and was going down the road. It's important, I think, for you to understand that with respect to Mr. Rickenwald, and you'll see under the policies, he didn't go back and have an investigative report created. There's no investigative report other than the one we're talking about, Captain Doffenmeyer's. And you'll see under the policies that is a requirement. It's a due process requirement before you charge anyone with any crimes. You've got to have an investigative report. And there's none, other than the one I just told you, which disputes the findings in his basis for dismissal. That is a feature, and that goes to show you that they had the opportunity to do it, but they couldn't. They didn't have the information. They weren't comfortable, and Captain Doffenmeyer, maybe today's fact that she's not here is some indictment as to the fact that they cannot change the report that they have, which is the basis of the employee's rights. At the end of this case, I think if we show you all of that evidence, we expect to show, you'll understand that this process was set in stone and it's being driven for political purposes. Being discharged because of Ashley Drury, Daniel Smith's, that not for what he did. No policy violation, specific policy violation. That this was a knee-jerk for the purposes of trying to create, if you will, a sense of a sense that the county was reacting to these issues on the beach, and not for actual conduct that he committed. So, at the end of the case, if we show you that evidence, we're going to ask that you reinstate Captain Gardner and that he be allowed to continue his employment since he's been suspended in October of last year.